Good day, I am Angel C. Javier from 1E2 BS Criminology. Today, I will share to you what I have learned on criminal justice system during the semester. So what is criminal justice system? Criminal justice system is the machinery of the state that enforce the rules of conduct to protect the lives and properties and maintain peace and order. It is intended to prevent and control crimes, protect the innocents, punish the criminals, and provide rehabilitation for the offenders. There are 5 pillars of criminal justice system here in the Philippines: the law enforcement, the prosecution, the court, the correction, and the community. These pillars have a very important role in criminal justice system. The law enforcement is the initiator of criminal justice system. They conduct, investigate, and gather evidences related to crime. Sila rin ang nag-file ng isang case sa prosecution. Ang prosecutor ang nagde-determine kung meron bang probable cause regarding the crime by doing the preliminary investigation. Kapag nakapatunayan na merong prima facie evidence, ipapasa naman nila ito sa court. Sa court ang court ang magde-decide kung meron bang kung innocent ba or guilty ang isang akusado. Kapag napatunayan na guilty ang isang accused, papadala siya sa correction. Ang correction naman ang mag-i-impose ng penalty na nagmula sa court. Then after serving the sentence, pwede nang bumalik ang isang offender sa community. Sa katunayan, ang correction ang weakest pillar of criminal justice system. Kasi ang gagawin lang nila ay susundin yung mga sinabi ng court, then after that, pababalikin sa community. Ganun lang yung trabaho ng court. But on the other hand, the purpose ng correction is to provide rehabilitation, reformation, and treatment for the offenders. Ngayon, pag-usapan naman natin yung prosecution. So, prosecution is a process or method whereby accusations are brought before the court of justice to determine the guilt or innocence of an accused. Ibig sabihin, ang prosecution ay isang proseso upang malaman kung ang isang akusado nga ba ay guilty or innocent. Prosecution is the discretion of prosecutors. Ibig sabihin, ang prosecutor ang nagsasagawa ng prosecution to determine if an accused is guilty or not. Always remember na ang isang akusado ay mananatiling inosente hanggat wala pang final judgment from the court. So, sino nga ba ang prosecutor? A prosecutor is a person who is a quasi-judicial officer who assumes full control and discretion over criminal case of administration of justice. Prosecutor represents the people of the Philippines in the criminal proceedings in court of law. They determine whether the evidence gathered by the police meets the standard proof to prosecute and convict the accused. Prosecutors also verified if the person arrested shall undergo the criminal justice process. Kung mababa naman pala at walang matibay na ebidensya, mababaw lang yung kaso, hindi na kailangan paabutin sa korte. Mayroong 3 prosecution system here in the Philippines. Ang una muna ay ang adversarial, inquisitorial, at mixed system. Anong meron dito sa adversarial system? Adversarial is also known as acquisitorial system. Ang may primary responsibility dito ay ang victim or his representative to find and present evidences in court. So, ang judge naman ang makikinig at magdedetermine ng applicable punishment for the accused. Sa inquisitorial system naman, the judge searches the facts, listens to the witness, and investigate if the accused is guilty or not. Sa mixed system naman, it is where the victim who provides the facts, evidences, and testimony to prove the guilt of the accused. The judge will listen investigate if there is a reasonable doubt and determine kung guilty nga ba ang akusado. The prosecution service is made up of chief state prosecutors, the regional prosecutors, the provincial prosecutors, and the city or municipal prosecutors. Ang tungkulin ng state prosecutor ay to administer cases against fiscals and other prosecutor officers. Kapag sinabi pong fiscal, ito ay another term for prosecutor. They are also responsible to prepare legal opinion involving the violation of revised penal code and special penal laws. Also, the state prosecutor is responsible to review appeals from resolution of fiscals and other prosecuting officers. Halimbawa, ang isang fiscal na nagsagawa ng preliminary investigation ay nag-issue ng resolution. So, the state prosecutor may review the appeal from the resolution of the fiscal. Ang tungkulin naman ng regional state prosecutor ay sila ang nag-i-implement ng plans, programs, policies, order, memoranda, rules and regulations of the DOJ relative to the prosecution and investigation of criminal cases within its region. Kapag sinabing implement, ibig sabihin sila ang nagpapatupad ng mga batas, ng mga plano, ng mga ordinansa, mga programa sa kanilang region. They also exercise immediate administrative supervision of all over provincial and city prosecutors. And they also prosecute any case arise in its region. Sa provincial and city prosecutors naman, they are in charge in the prosecution of all crimes and misdemeanors and violation of city and municipal ordinances in the court. Ibig sabihin, sila ang nagpo-prosecute ng lahat ng krimen at saka yung mga violated ordinances sa loob ng kanilang municipality or city. They may also prepare information or complaint against the person accused of the commission of crimes. Also, the provincial and city prosecutors may issue subpoena to get the evidences from the witnesses. Ang sunod naman nating discussion ay about inquest. What is inquest? Inquest is an informal or summary investigation conducted by a prosecutor to a person who is arrested and detained without the benefit of warrant. It is done for the purpose of determining if the person should remain under the custody and correspondingly in charge in court. Pag-usapan natin kung paano o kailan nagsisimula ang inquest procedure. Inquest procedure starts kapag ang law enforcement ay nagpasa ng referral document or complaints sa isang inquest prosecutor na naglalaman ng mga sumusunod: affidavit of arrest, investigation report, statements of the complainants and witnesses, and other supporting evidence gathered by the police in his investigation involving a detained and arrested person. Pagkatapos, the inquest prosecutor will then determine whether the matter is proper inquest case, the arrest made by the police is legal, and in accordance to Section 5 of Rule 113 of 1985, Rules of Court. If the inquest prosecutor finds that the arrest made by the police is not proper, the prosecutor may execute the following. Number 1. Recommend the release of detained or arrested person. Second, note down the disposition on the referral document. Number 3, prepare brief memorandum indicating results of the action taken. And the last is forward the case to the provincial or city prosecutor for the appropriate action. And when the arrest made by the police officer is proper, the inquest prosecutor shall start the preliminary investigation. Yun nga lang, preliminary investigation lasts for 15 days upon its inception. Kung kaya, pwedeng mag-request ng ang prosecutor ng waiver for the respondent para hindi siya ma-charge ng arbitrary detention or violation of Article 112. Sa pagka-comply ng waiver of the respondents, waiving the Article 125 of Revised Penal Code, kinakailangan ng assistance ng counsel at saka ng presence ng arrested person. Pagkatapos, the inquest prosecutor will then forward the case to city or provincial prosecutor for preliminary investigation. And when the person did not execute the waiver, the prosecutor must proceed in inquest by examining supporting evidences presented. And if the inquest fiscal finds a probable cause, he shall recommend the filing of complaint or information in the court indicating the offense committed and the amount of bail recommended if bailable. At ang panghuli, kinakailangan na may approval ito ng city or provincial prosecutor with the certification by the filing prosecutor. So, diba, napakahaba ng proseso ng pag-file ng kaso sa korte. Kinakailangan dumaan sa inquest procedure, sa preliminary investigation, bago pa maisampa yung case sa korte. Kaya minsan bumabagal ang proseso ng pagkuha ng justice ng mga tao dahil sa napakaraming cases na nakatambak sa court. Kung kaya inirerekomenda na mas mabuting dumaan muna yung kaso sa barangay para sa halip ay matulungan natin yung mga tao na kailangan talaga ng justice. Who are the officers authorized to conduct preliminary investigation? First, meron tayong provincial or city prosecutors and their assistants. Second is the national or regional state prosecutors. At ang pangatlo ay such other officers authorized by the law. In crimes committed with 6 years and below of imprisonment, the complainant may directly file the complaint directly to the court who has jurisdiction over it, such as the municipal trial court, municipal circuit trial court, and metropolitan trial court. So, yung mga kaso naman na may 6 years and above, the complainant may directly file the complaint directly to the prosecutor's office for preliminary investigation. So, what is preliminary investigation? Preliminary investigation is an inquiry or process of determining whether there is a sufficient ground to engender a well-founded belief that a crime cognizable by a court has been committed. Preliminary investigation is conducted before the filing of complaint or information of an offense with a prescribed penalty of 4 years, 2 months, and 1 day without regard to the fine. Its purpose ay para malaman kung meron nga bang prima facie evidence that exists. Kanina ko pang binabanggit yung complaint or information na yan. So, ano nga ba yung complaint? Complaint is a sworn statement charging a person with an offense subscribed by the offended party. Ito yung habla, ito yung ikinaakusahan yung isang tao, yun yung sinasabing complaint. So, ano naman yung information? An information is an accusation in writing charging a person with an offense subscribed by the fiscal or prosecutor and filed in the court. Ito naman yung galing sa prosecutor at fiscal against the person. Kailan natin masasabi na ang isang complaint or information is sufficient? Una, name of the accused. Second, designation of an offense. Pangatlo, an act's complaint constituting the offense. Pang-apat, name of the offended party. Pang-lima, proximate time of the commission of offense. At ang pang-anim, place where the crime has been committed. And that's it. Hindi lang po ito yung mga natutunan ko. Napakarami kong natutunan. Yung proseso, kung paano ba nangyayari, lahat. Lahat ng mga questions noon ay nasagot na. So I am very thankful of having Mrs. Eleni to be part of my journey, of our journey as a criminology student. Thank you!